Maybe Lordship.
Yes,
Lordship, maybe allowed to mention item 48, Lordship, from the hearing list on behalf of Mr. Taliao. Lordship is not keeping well, so it's a matter came up after 3 weeks, Lordship.
this is a 2017 matter, Mr. Proceed.
Yes, Lordship, but the matter is led by Taliao, Mr. Taliao, and he's not been keeping very well, so Lordship may kindly consider
I think
here and
our friends should also do justice to their client, 2017 maybe.
his Lordship.
We'll give you a week's time.
But it's 2 weeks, Lordship.
No, we'll give you a week's time. On the prayer of the learned counsel for the petitioner listed on 29/5/2023. It is made clear that there shall be no further adjournment.
Obliged, my lord.
My lord, I may be allowed to mention item 49, 50, 51, analogous. I want to file a affidavit in reply to the additional affidavit in opposition filed by my learned friend. So I may be granted 2 weeks' time.
At this juncture,
Yes. My learned friend filed a additional affidavit in opposition.
additional affidavit in opposition.
My lord, of course, that is in my favor, actually, placing the seniority list, which I do not. On that basis, I want to file a small reply.
That
to
means the
that.
government has filed affidavit in opposition plus additional affidavit.
My
in
lord,
opposition.
my lord.
Okay. Mr. M.T. Longja, the learned counsel for the petitioner, 6 for 2 weeks adjournment to file affidavit in reply to the additional affidavit in opposition filed by the state respondent. Prayer is allowed, listed accordingly.
Much obliged.
What?
May I please, Lordship. Lordship, I beg to mention item number 15 to 25.
52.
15 to 25. Here we are yet to receive our file our counter.
Let us see, let us come as per the list. Let us see what was the last order passed, okay?
Obliged, Lordship.
We'll allow you, but
May it please, my lord.
yes, please.
Hearing item 47, my lord, I may be given a week's time, my lord.
This is
Item 47.
2017 matter.
Yes, my lord. The previous council expired and then I recently entered, my lord.
That is the submission which you are making for a very long time.
Yes, my lord. And my lord, there is a chance that, my lord, a likelihood that the case will be withdrawn, which is why, my lord, a week's time, my lord, kindly.
Give a fixed date. We'll give you a last chance,
My lord,
not more than a week.
my lord. Yes. My lord, 25th. Next week.
5th
Yes, 25th.
of 25th. Yes. On the prayer of Mr. Senti Younger, the learned counsel for the petitioner, listed on 25/5/2023. It is made clear that there shall be no further adjournment.
My lord, deeply obliged.
May it please, your lordship. I beg to mention hearing item number 52 and 53. On behalf of my senior Moaz Amir counsel for the petition. Lordship, my senior has some personal difficulties to take up the matter today. So kindly list it on fixed it on 25th of this month, that is next week, for hearing.
On the prayer of Mr. Moaz Jamir, the learned counsel for the petitioner, listed on 25/5/2023. Yes,
Obliged, my lord.
Yes.
My lord,
Yes.
if I may be allowed to withdraw the current IA petition for necessary and then file afresh for necessary implement.
MS Renzo, the learned counsel for the petitioner, submits that she may be allowed to withdraw the application with liberty to file afresh. Prayer is allowed. The application stands closed. Okay.
Much obliged, your lordship.
May I please the lordship?
Yes.
Lordship, I'm for the state respondent, lordship. Lordship, on the last occasion, this honorable court has directed the state respondent to take instruction as to whether the private respondent was appointed on compassionate or through advertisement process, lordship. And lordship, to that effect, lordship, I'm yet to receive instruction, lordship. So a short time may be given.
Yeah, file your affidavit.
Lordship, I have filed
What
my.
was
affidavit.
your stand in the affidavit?
The stand of the state respondent is that the private respondent there was an inadvertent on the part of the Deputy Commissioner Teng Sang to inadvertently appoint one post access appointment, lordship. Here the petitioner is challenging the advertisement process, lordship. Lordship, here the advertisement is for 37 posts of the Bashi. But however, inadvertently, the Deputy Commissioner Teng Sang has appointed one, which was reserved for compassionate appointment. That was inadvertently.
What does the advertisement says?
Advertisement is
posts?
37 posts,
And how many people, persons you have appointed?
38, one access appointment, lordship.
So you are the 38th person.
My lord.
They are
I'm
the
not aware.
petitioners. They are the petitioners. lordship.
So the other petition.
They are the petitioners.
So what is your prayer?
My lord, I'm not in this matter, so my lord, I'm not aware of the facts.
Lordship, on the last occasion, this honorable court has directed to take instruction as to whether they were the private respondent were appointed on compassionate or through interview process, lordship. We have earmarked that one person named Sangsuli Sangtam. He was inadvertently appointed. So to that effect, lordship, this honorable court has directed to take instruction, lordship. So lordship, I have been informed that the matter has been sent to the commissioner, lordship, and I'm waiting for the instruction, lordship.
As
So
ordered on 25/4/2023. Mr. V. Jimomi, the learned government advocate, shall place the instructions before this court on the next date. That is when? Give a date.
um, 24.
24th of this month.
Uh, Today is 16. Today is 16 now.
Or you
26.
will on 30th. On
Lordship.
30,
Lordship.
that is on 35/2023.
May please lordship,
Yes,
my lord, I may be giving 3 weeks to file reply.
reply affidavit,
To the government.
yes, you have been seeking since last June.
Yeah, as per government affidavit in the position, I am not the only landowner, so I have to get clarification from.
No, that's okay, but your submission today, this is the submission which you have been making since June 2022. Reply. Yes, government, you have filed your affidavit?
Yes.
Mr. So-and-so, the learned counsel for the petitioner. Submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents.
State respondent.
State respondents. Prayer is allowed. Listed after 2 weeks.
Much obliged, madam.
This is which item?
Item 3, my lord. There I am for the private respondent, my lord. I have raised some preliminary objections, my lord. So. They have filed affidavit in reply to my preliminary objections, the petitioners. The private respondent, he is already out of service, my lord.
Yes, who is government advocate? Who is for the government?
And for the.
Where is your record?
Report is, yes.
What does the record says? And for what reason the record was called for?
I don't know how record was called for. Because.
No, you record, you keep the record in your, tell me.
It's with me.
Tell me for what purpose the record was called for.
Record was called on the prayer of the petitioner. On the prayer of the petitioner, record was called. Lordship, the fact is very simple. Now, the petitioner was appointed and he was appointed for a centrally sponsored scheme.
The private
Okay.
respondent. Private respondent.
The private respondent,
Uh,
whose appointment the petitioner has challenged by this petition. Now, petitioner has resigned the service
uh,
on 1st April 2021, after serving for 1 year.
okay.
Because the scheme under which the private respondent was appointed was discontinued. So now, here it is infractious. And a sense that petitioner is trying to revive a person who has died in 21.
Hmm.
Now it is 2023.
So the respondent number 7 has
Already resigned.
left the service.
Yes, my lord.
What is the prayer of the petitioner?
To appoint him in place of the private respondent.
Whether he has been appointed?
No, my lord, I have been appointed. He is challenging my appointment.
That's why.
Now I have already left service after
Ah,
serving for 1 year.
After you left service, whether he has been appointed?
No, my lord.
No.
No, my lord. I don't think his prayer can get
Ah,
accommodated at this stage, my lord. At
ah,
this point, my lord. It is impossible, my lord. Because
ah.
the scheme was only for 1 year and the appointment itself, it clearly mentions that the appointment is only for a period of 1 year.
It's an appointment under a scheme.
Yes, my lord.
And the period is only for 1 year.
Yes, my lord.
And that 1 year has expired.
Yes, my lord.
And respondent number 7 has retired.
Respondent number 6, I am already out of service.
You are
Yes.
out.
Yes, my lord.
Whether the scheme continues.
Scheme is discontinued, your lordship. Scheme is discontinued.
Discontinued.
Discontinued. Because it
Have you
is-
stated in your affidavit? Whether you have stated in your affidavit that the scheme is discontinued?
But at this stage, my lord, the prayer of the petitioner has become infructuous.
That may be your submission. What the court wants to know is whether the scheme continues. What is your grievance now?
My lord, as per government letter dated 9 February 2021, though the respondent service, he was discharged. It was on certain condition that that post will be kept in abeyance till the final disposal of this petition.
Okay, but he has resigned. So what do you want? He has resigned. You were against his appointment. He has resigned. What right do you have to be appointed to that post? Now tell me. Yes. What cause of action remains now when he has resigned? Who is leading you?
My lord,
Who is leading you in this case?
Asia.
We will list it next week. Will he be there?
I hope so, my lord.
Will he be there?
I hope so.
If
My
you
lord,
are
maybe,
hopping,
my lord, maybe up to 2 weeks then.
if you are hopping, we'll fix a date.
Okay, my lord.
And what is your objection, Mr. Santi?
That the prayer of the petitioner has become infructuous, my lord. The case has become infructuous, my lord. And that, my lord, a person who has taken a calculated chance and participated in the selection process, he cannot turn around and challenge the selection process. That law is well settled, my lord, in Matan Lal's case, my lord.
You tell me facts. You tell me the facts.
My lord, if, my lord, since the leading counsel is not here, my lord. If it can be listed on another date, my lord.
He was the lone candidate
That is
for the
their-
post.
Their claim, my lord. It is a walk-in interview, my lord. The term walk-in interview itself connotes that, my lord, any interested candidate can walk in and give the interview, my lord.
Okay. On the prayer of Mr. So-and-so, the learned counsel for the petitioner listed on.
Next week.
Yes, give a date.
My lord, 25 or 26.
Listed on 29/5/2023. Okay.
Deeply obliged, my lord.
Lordship, I have some personal difficulties today, so if this matter can be passed over for the day.
After a week. On the prayer of the learned counsel, on the prayer of Mr.
Yeah, all right.
Yangarwati, the learned counsel for the respondent number,
For the, all the
All
responses.
the,
for all the respondents, listed after a week.
much obliged.
May I please, your lordship. Lordship, in this matter, the pleadings have been completed. Kindly fix it, list it on, for list after 2 weeks for hearing.
Okay. It is submitted by the 11th Council for the parties that pleadings are completed and therefore the matter can be listed for admission hearing. Listed after 2 weeks.
Thanks, my lord.
What is the matter about?
My lord, it is more or less like your Nisibi.
What?
One Nisibi case was taken to the Supreme Court where without considering the pension rules, the order passed by this honorable court was set aside. So it is more or less in the same manner, but only the thing is that I'm basing my case on the rules. My lord, the pleadings are completed.
How many years you have served? Yes, Mr. MT.
Yes.
How many years you have served?
16 years, 1 month in 13 days, my lord.
16 years.
Yes, 1 month in 13 days.
What was the nature of your appointment?
My lord, first appointment is Annexion 1.
No, what is the nature of your appointment?
This is work charge,
Uh,
but it is against a vacancy. Page 10.
hmm,
I may be allowed to read out, my lord.
hmm.
Sri such and such is hereby appointed as work charge painter helper in place of Sri such and such who has been absorbed into regular carer in the scale of pay of rupees such and such in the scale of pay. Plus all other allowances under the rules admissible from time to time with effect from the date of training to the post. Right, such and such. The appointment is purely temporary and may be terminated without further notice.
Hmm.
So what I'm basing my lord is that it is a clear vacancy. Yes, the nomenclature is work charge. So he was appointed in the scale from the day 1 and under the STO housing OCA. Then his service was maintained all along. And
He served as work charge for 16 years.
yes, my lord. in Annexure 19, page 19. Like all other regular appointee, he was transferred from subdivision STO Oka to PWD Housing, subdivision number 1, Kohima, on 3rd September 2008.
And what is the case you were mentioning about the Supreme Court?
My lord, there was a case before your lordship here.
Oh,
It was in the similar nature that somebody was working as a work charge, but he died while in service. His wife approached this court. This single bench allowed the petition. Also, the division bench, and it was taken to the Supreme Court. So what happened is that in that case, the issue was that he approached the court belatedly, the wife. Next issue was he had not applied for regularization, that this is employed. In my case also, there is no application for my regularization. The difference will be there is no delay in the
see,
present
basically,
case.
you are seeking for regularization so that you can enjoy the pensionary.
My
benefits.
lords,
Okay, we'll hear you. We'll hear you. Revised list after some time.
my lord.
I can start, I can see 106.
May it please, my lord.
Yes,
My lord, I may be given 3 weeks to file my affidavit in reply to the affidavit in opposition filed by the respondents 1, 2, and 3, my lord.
Mr. Sinti Amar, the learned counsel for the petitioner, submits that he may be allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 1, 2, and 3. Prayer is allowed, listed after 3 weeks.
Deeply obliged.
Item 8, WBC 399, 2021.
May it please, your lordship, for the petitioner.
Yes.
Lordship, pleadings have been completed. Let it come up for hearing after 3 weeks.
Okay. It is submitted by the learned counsel for the parties that pleadings are completed and therefore the matter can be taken up for admission hearing.
Obliged, my lord.
Listed for admission hearing after 3 weeks.
Right, Rashid.
Item 9, WBC 305, 2021.
Will you please, Your Lordship, let the matter be listed after 2 weeks. Your Lordship, I have already filed my counter.
I have no objections, my lord, to the.
What is
Yes, my lord, on this, the similar question of law, my lord. A writ appeal has been preferred, my lord. Here, I was serving as work charge employee till my superannuation, my lord. Now, after my superannuation, I have approached this honorable court praying for regularization of my service, my lord. I was a work charge employee.
how many years you have served?
I have served for, my lord, 35 long years, my lord.
Yes, there is a decision of the Supreme Court. For those who have served 35 years, 35 years without regularization, they are entitled to pensionary benefits. You cannot actually use the service of somebody for 35 years, exploit them, and then send them home empty-handed. Okay, anyhow,
My lord,
what is your prayer?
my prayer is for regularization of my service. my
No,
lord.
no. You want it to be listed for hearing?
After 2
Yes,
weeks,
Your Lordship.
2 weeks.
my lord.
On the prayer of the learned counsel for the parties, listed for admission hearing on, give a date.
On 29th, my lord.
On 29, that is, what is the date?
Monday, my lord. 29th,
On
yeah,
29/5/2023. Come prepared.
my lord. Keep the.
By please, your lordship, I'm appearing on behalf of my senior Moa Jamir, counsel for respondent number 1 and 2. Lordship, my senior has some personal difficulties to take the matter today, so kindly listen for hearing after 1 week next week.
Have you filed your reply affidavit?
Yes, yes, my lord.
File it. Mr. So-and-so submits that. Mr. Moa Jamir, the counsel for the petitioner leading the case, has some personal difficulties and therefore prays that the matter may be listed after a week. Prayer is allowed, listed accordingly.
Obliged, my lord.
May I please, your lordship?
Yes,
Lordship,
Lordship.
in the last occasion, last chance was given and that in case the respondent don't file affidavit, the matter will be disposed of on the basis of record because it is an admitted case. The private respondent has filed his affidavit.
okay.
He has admitted that he received a
And who is for the private respondent? Ma'am?
Chief, I'm for the respondent number 6.
6. Okay, so what is the admission made by the respondent number 6?
that he has received the money, which is not meant for him, but meant for the petitioner. The administration gave it to him, he took it. And now the petitioner is running from pillar to post for the amount.
So, madam, you have taken somebody's money. Return it. I haven't gone through your affidavit, but seems you have admitted that inadvertently you have taken the money. So return.
It is the administration's fault, your lordship.
Yes, Mr.
Yeah.
Beto. Is that correct?
Your lordship, since
What the respondent number 6 has submitted? Is that correct?
Lordship, that is a submission of the petitioner. However, as far as the state respondent is concerned, I'm yet to receive instruction, Lordship. So I'm unable to make my,
But see the last order. See the last order.
Lordship.
And in regard to the last order, what steps have you taken? At least apprise this court. What steps have you taken? At least the court has given you the last chance. So what steps you have taken as the counsel for the state?
Lordship, I have sent a reminder letter to the respondent, Lordship, by letter dated 21st February 2023, Lordship. But till such time, Lordship, I am yet to receive instruction, Lordship. I have sent a reminder, Lordship.
Let us see that letter. And where is the admission of the respondent number 6? Where is the admission of the respondent number 6? Which para?
Yes, show the paragraph.
Lordship, in point number 6 of my affidavit in position. On page 3.
Who is the respondent number 5?
Is the council chair? Your Lordship, he's the chairman of the village council, Your Lordship. He issued a certificate to the effect that the petitioner and the private respondent are one and the same person. And on the basis of that, the administration issued release the fund, the amount. Subsequently, upon complaints by the petitioner, the respondents also took some steps directing the private respondent to refund the money. But no further action was taken, and obviously the private respondent is also in no position to refund it. He has nothing.
He says he has spent the money.
Yes, he spent the money and it was the administration that released the fund to him. The administration has also realized there is something fishy in the transactions, Your Lordship. Something very fishy in the transactions, the manner in which the money was released. And subsequently, the petitioner received some 2,50,000. No, on one occasion 2 lakhs and on another occasion 40,000.
How much you are supposed to receive?
And 11 lakhs, it's 11,48,605. And despite repeated requests, the respondents have not taken any further action. Because of that, the petitioner has been compelled to approach this honorable court for a direction. Because this transaction had nothing to do with the petitioner, but it is the administration, the village council authority, and the respondent number 5 who are responsible. Now, in this case, since the respondent number 6 is in that position, it is for the administration to recover it from him, not the petitioner. And the state respondents may be directed to release the fund due to the petitioner and recover it from the private respondent in the interest of justice.
Which item is this? Which item?
11. It's item 11.
11.
You are led by Mr. Fuseko? Where is he? Yes, Mr. Fuseko, you are hiding behind the veil. Yes, what happens now? You have taken the money.
Lordship, yes, Lordship, the district administration, while carrying out the road construction, have damaged my land also. And in that respect, I have written an application and complaint to the village chairman. And the village chairman stating that the name being similar, he has issued a certificate stating that I am the person that is a petitioner and the money has been released in my name. Whereas the district administration has not released the
Your money.
compensation due to me, Lordship.
And what is the amount due to you?
Lordship, that is for the district administration to assess and give me, Lordship. Not me, Lordship, but as per the National Highway Act, how the compensation should be given. So in that respect, since I was in the dark that The money which was given to me is the money.
Have you applied for any amount as compensation?
No
Have you
specific
applied for any amount?
No specific amount. But Lordship, I've given the area of my land that has been damaged, Lordship. So now, Lordship, after that,
Mr. Tom Pok, maybe it is not very intentional also, because
no, Lordship.
he has also actually, his land was also,
Your lordship, I only want my money back, which is due me. Only that. I have no intentions against any of the parties.
so
Only that-
why don't you recover the money? Since it is not yours, and when your turn comes, you get your money from the government.
Lordship, but the summons issued by the district administration came after 6 months. And within that time, the money left with the deponent, that the respondent 6 was deposited before the SDO. That is 2,40,000
Out of,
out of 11,46,000.
you are also a big mounted man. Huh?
Lordship,
You consume the money so fast.
Your lordship, it is a funny thing that these are villagers,
Lordship.
simple-minded people. So
Yes, Lordship.
immediately
I
on
know.
receiving the money, he
I know.
bought some
plot of land and
Ah.
rifles
Please.
and so on, and he finished the entire amount. Now he's in no position to recover it. And it is the administration's fault now, because I had nothing to do it in the first place. So the administration must give me my due, and then if necessary, recover it from the.
Yes, Mr. Beto,
Yes.
ultimately, I think the problem is with you.
Lordship, I'm allowed some time to get necessary instruction, Lordship. Since in the last occasion, I have sent a reminder letter. And then I had a series of communication with the officials also, Lordship. But till such time, Lordship, I've yet to receive instruction.
It is, in fact, it is also not the government, but it is the district administration.
Yes.
Lordship.
Yes, Mr. Tompok, let us give one more chance
Your lordship, your lordship.
in the interest of justice.
Yes, your lordship.
Because I think without there being anything from the government, it will be difficult for this court to decide also.
yes, Lordship.
And
Ultimately, it will come down to the same order, even if it is passed today, your lordship, but it is. I have no objection to giving it one last chance.
By the order dated 24/4/2023.
And Lordship, respondent number 5, he is also the main party, Lordship, since he is the chairman who issued the certificate, Lordship. Certificate to respondent number 6, Lordship. And but respondent number 5 is not here before this honorable court.
In fact, it is the government who should represent this chairman also. The chairman is a statutory authority
Yes.
Lordship, but
working under the district administration.
it is at the behest of the chairman, Lordship.
No, that's why I'm saying,
The
since the chairman has been impleted, it is the duty of the government to represent this chairman. Because village council is a statutory authority working under the district administration. So in fact, you are supposed to represent them. You are just shelving out. You are just segregating the chairman. I don't know for what reasons, but you were supposed to represent the chairman also. by the order dated 24/4/2023, the state respondent was given the final chance for filing the affidavit in opposition, failing which it was ordered that the matter will be considered as per the documents available. So today, when the matter is listed, Mr. V. Momi, the learned government advocate, submits that consequent to the order dated 24/4/2023, he has submitted the written reminder dated 21/2/2023. Oh. The order was 24/4/2023. This is 21/2/2023.
Lordship, Lordship.
What steps have you taken pursuant to this order?
Lordship, I had a communication with the official Lordship, and they are supposed to send me.
Cancel that order.
After the notice was sent, Lordship, reminder was also sent to the respondent authority, Lordship. In the meantime, I had a series of communication with the official.
Series of communication will not do.
Lordship.
This court wants record. You are misguiding the court. Please take. Okay, by the order dated 24/4/2023, the state respondent was given the final chance for filing the affidavit in opposition, failing which it was ordered that the matter will be considered as per the documents available. Today, when the matter is listed, Mr. V. Momi, the learned government advocate, submits that consequent to the order dated 24/4/2023, he had made verbal communications with the state respondents to comply with the order dated 24/4/2023. Stop. The submission made by the learned government advocate is, however, not supported by any record. Be that as it may. The state respondent is once again given an opportunity to file the affidavit in opposition. Stop. Failing which it is made clear that on the next date, if no affidavit is filed, cost shall be imposed on the state, and the matter
Lordship,
shall also,
as a last chance, Lordship.
yes, and the matter shall also be taken up on the basis of the pleadings available. That's why I am ordering, if on the next date fixed, you fail to actually submit your affidavit in reply, we will impose costs on these state respondents on the next date. We are giving you sufficient time. Listed after 3 weeks. Yes. Mr. Nangami.
May I please, my lord?
Yes.
Lordship, in this matter, I have received the pair-wise comment.
Okay,
However, Lordship, some documents as well as some clarifications are still required.
okay.
If 3 weeks' time can be granted to me to receive those documents as
Mr.
well as clarification.
And Nangami. The learned senior government advocate submits that he has received the pair-wise comments from the state respondents. He, however, submits that some more clarification is required. And therefore 3 weeks' time. Prayer is allowed, listed after 3 weeks.
Deeply obliged, my lord.
Yes.
Much obliged.
May I please, your lordship.
Yes,
Lordship, here I have instruction to withdraw the matter, your lordship. Your lordship, since here the petitioner is praying for release of outstanding bill, your lordship. Here the respondent
They have
already
released.
released, your lordship.
Yes, my lord, we have already.
yes. Mr. M. Solo,
Your Lordship.
the learned counsel for the petitioner submits that he has instructions to withdraw the present petition. Stop. The present writ petition is accordingly closed as withdrawn.
Your Lordship. Much
Deeply obliged, my lord.
May please, your lordship,
Yes, Ms.
Lordship.
Lika.
on behalf of AIM, your lordship, let the matter be fixed after 1 week.
Who is the counsel for the petitioner?
Hmm,
None appears for the petitioner. Listed after 3 weeks on a date to be fixed by the registrar.
May bless Lordship.
Yes,
Lordship, in item
what is this?
23 and 24. From 15 to 25 are analogous matter, Lordship.
From
15 to 25.
15 to
And then you speak of item 23 and
15
24,
to,
25.
yes. What is the matter about?
And you speak of item 23 to 24, 23 and 24. Lordship, I have instruction to appear on favor of private respondents.
23, 24.
Yes, I'm yet
Okay.
to file my bakalarama.
Okay.
So may I breathe out the matter may be listed over 3 weeks.
What about the other items?
I'm appearing only in 23 and 24. Lordship.
Yes, Mr.
The petitioners are challenging the appointment of private respondent in all the rate petitions, Lordship.
Private respondent constables.
In item,
Item 18, I am appearing here, on behalf of the private respondent. I am going to file. Earlier.
so item 18, Mr. Tongpok, you are for item 18.
Yes. Your Lord.
For respondent number,
All the private respondents, all the private respondents. I am yet to file the Wakalan Nama, your lordship, because the petitioners are in, the respondents are in disparate places. I have asked them to.
what about item, let us go serially.
Yes.
What about item 15? 15? Mr. TB Jamir is appearing 15?
No, lordship, we are preparing for the department. 2, 3, 4.
So you're for 2, 3 and 4.
2, 3, 4, and 5.
2, 3, 4 and 5. That is Mr. TB Jamir
Lordship,
in all the cases.
lordship.
Okay, okay. And Mr. Yanangami, you are for 1. Chief Secretary.
Lordship.
Okay.
Your Lordship. I'm appearing for item number 19 and 21, Your Lordship.
19 for private respondents.
Yes, Your Lordship. Private
Nine,
respondents in item number 19 and 21, Your Lordship.
okay, heard MS Judge Jimomi, the learned counsel for the petitioner. Also heard Mr. I Jamir, you are I Jamir
Lordship.
for also heard Mr. N. Angami, the learned counsel for the respondent number 1, and Mr. I. Jamir, the learned counsel for the respondent number 2, 3, and 4.
2, 3, 4, and 5.
2, 3, 4, and 5, sorry. Mr. Tongpok, the learned counsel for the respondent number
23, 5 to. Your Lordship, 5 to 94. 94, Your Lordship.
the
5 to
learned counsel for the respondent number 5 to 94. Okay, Mr. Tongpok, the learned counsel appears for the respondent 5 to 94 in WPC 192/2022. And Mr.
What is your?
Kohima Jamir appears for the respondent number
Respondent number 6 to 59. And WBC 197. Item 23.
which item?
Item 23,
23 and
24.
appears for the respondent number
6 to 59.
6 to 59
In item number 23
in WPC 197/2022
is
and for the respondent number
6 to 63.
6 to 63 in WPC 198/2022. Mr.
Lordship,
Stop, Mr. M. Solo appears for
respondent number 7 to 54, Your Lordship.
which one?
Item number 19, Your Lordship. WPC 193,
Appears for the respondent number
7 to
7 to
54, Your Lordship.
54 in WPC 193/2022.
2022. Lordship, and item number 21 as well, Your Lordship. For the private respondents,
And for the respondent number
8 to 94, Your Lordship.
8 to 94 in WPC 195/2022.
Lordship.
The learned counsel for the respondents. Have you filed your affidavit?
No, Lordship.
The learned counsel for the respondents. 6 for adjournment to file their respective affidavit in opposition. Stop. Prayer is allowed. Listed after 3 weeks. Okay? Okay.
May it please, your Lordship. Lordship, here I'm appearing for respondent number 6 to 37, Lordship. Lordship may grant me 3 weeks time to file my counter, Lordship.
6 to,
6 to 37, Lordship.
okay. Okay,
I have
MS.
objection, my lord.
And what about the government?
I'm for the respondents, 1, 2, 3, and 5.
Yes, you're for the
six
respondent, but
five,
you have filed.
Lordship.
Okay, very good. You're for 6 to 37.
Yes, Lord.
Miss Luciano, the learned counsel for the respondent number 6 to 37. 6 for 3 weeks' time to file the affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed up to 3 weeks. Okay.
Replies, please.
Your Lordship, on behalf of Moim Jin, 3 weeks may be granted for filing counter.
The learned government advocate, 6 for 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed accordingly.
Your lordship may kindly grant me 3 weeks' time, your lordship.
Okay, Mr. N. Angami, the learned senior government advocate, is granted 3 weeks' time to file affidavit in opposition on behalf of the state respondents.
Much.
Deeply obliged, my lord.
Your lordship, instruction has been received, your lordship, so 3 weeks will be granted.
MS Livika, the learned government advocate, submits that instructions has been received and therefore she may be allowed 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
Your lordship, I have a subpoena prayer for 30 also.
This is 30.
Yes.
This is 29.
Yes.
Same order for 30. Okay.
Your lordship, on behalf of AIME, 3 weeks may be granted. Yet to receive instruction.
The learned government advocate seeks for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Similar prayer, your lordship.
Okay, same prayer.
Much obliged.
Your lordship, I pray that this matter may be listed after 4 weeks. To file.
You file your affidavit?
Affidavit in
Lordship.
reply.
You file your affidavit? Mr. So-and-so. The learned counsel for the petitioner seeks for 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 3 weeks.
I oblige.
Yes, Mr. Fuseko, what is this?
Lordship, the last occasion, this honorable court is directed to take steps, fresh steps on the Lokayutta. I've taken steps and till now, Lordship, they have not appeared, Lordship, Lokayutta.
Yes, Mr. I. Jamir. I think Mr. TB has been appointed as,
No, lordship. Lordship, we have been appointed for case-wise, privately engaged case-wise, not as a standing counsel. So we have no instruction regarding this matter.
who are the other respondents? Okay,
Government.
Mr. MT,
Yes, Your Lordship.
what do we do?
Your Lordship, direction should be given to the Lokayuda because it has been pending since 2018.
Yes, Lordship, because as per this honorable court's order dated 23, I was directed to take fresh steps. I've taken that. Until now, they have not come. And it's not that the office is not functioning, but
Yes, Mr. Nangami, this is the reason why I wanted your presence. Why don't you tell the chief secretary that
Lordship,
this Lok Ayukta
lordship.
is not taking steps to protect your orders?
Lordship, it can be communicated, your lordship.
Because I think on many of the cases, we have issued notice, but nothing has happened.
Lordship,
Maybe they are also not interested to pursue this matter because this was formally taken up by the vigilance.
Lordship. But
This
Lordship,
is a vigilance case,
yes, Lordship.
erstwhile vigilance.
Yes, Lordship.
I think that is why they may not be interested also.
Lordship.
Lordship, even otherwise also, since they don't have a standing council, I cannot, but the Lordship matter before the vigilance is pending, Lordship. And the Lok Ayuktha is. The special judge Lok Ayuktha is taking over the case, not the vigilance.
What are you challenging in this order,
Lordship, I'm challenging.
in this petition?
Lordship, the contention of the petitioner is that the petitioner is a public, not a public servant, and he cannot be work under the PCA. He's a contractor.
He is a contractor, but
He's a
if he is hand in gloves with the officials, he can definitely be booked. Only thing is that whether he is in hand in glove with the officials or not,
No, Lordship.
that is the issue.
The petitioner on,
But actually, the law is clear that even a private person, a public, can be charged under the PC Act, provided he has connivance, he has connived with the public officials. The law is clear.
that's why senior will argue. Not my senior, Lordship, arguments we advanced by my senior. This is a cross. Lordship can give a direction to the Lok Ayuktha to appear on in this matter, Lordship, because several steps have been taken. Without their presence for this honorable court, this honorable court may not be able to execute properly, Lordship. So if Lordship may kindly send a note in the direction to appear.
Mr. MT, what is the stand of the state?
Your Lordship, here we have a less arena to play in this case. But Your Lordship, here, Lok Ayuktha, earlier initially it was handled by the Nagaland State Vigilance Commission. And because of the election of the Lok Ayuktha, now Lok Ayuktha is a statutory party. So to my opinion, Your Lordship, a direction may be given to the Lok Ayuktha, whether to appoint or to proceed without the council of the Lok Ayuktha. Because it's a statutory party, Lok Ayuktha.
Mr. Museko, the learned counsel for the petitioner, and Mr. M. Timson, the learned additional advocate general for the state respondent. Number one. Stop. None appears for the respondent number. For the respondent number 5. Despite notice. By the order dated. Two, 3/2023. As well as by the order dated 23/3/2023, the respondent number 5. That is the Lokayukta Nagaland was directed to appoint a council to represent the Lokayukta. However, despite the order, the respondent number 5 has not taken any steps to appoint the council, and due to which this court is facing difficulties to proceed with the case. Mr. N. Angami, the learned senior government advocate, shall accordingly take up the matter with the Chief Secretary Nagaland. It is made clear that if on the next date there is no representation on behalf of the respondent number 5, the case shall proceed. On the basis, the case shall be heard and disposed on the basis of the pleadings available on record. Listed on.
Lordship, on
Give some more time.
12th of June.
Listed on 12/6/2023. A copy of this order may be furnished to Mr. N. Angami, the learned senior government advocate.
Highly obliged.
Item 27.1.
May I please, your lordship?
Yes.
My lord, this item is wrongly clubbed with item number 38. Actually, it should be listed along with 232 of 2021, not 2022.
232.
Of
232 of
2021.
2021.
Yes.
So 148, 149, these are all wrongly listed.
Yes.
Is it?
Yes, Your Lordship.
The learned counsel for the parties. Two, three, two, 2021 or 2022?
2021.
What happened, please? So give me one by one, let's see. 237. 237. It is submitted by the learned counsel for the parties. One by one. That the present writ petition, namely WPC 237/2021. Has been wrongly listed with the other writ petitions, which are in serial number 38, 39, 40, and 41. Stop. The writ petition WPC 237/2021 shall accordingly be segregated from the other writ petitions and shall be listed along with WPC 232/2021.
Yes.
Yeah. So this, what do we do this? So.
This has to be listed in the single.
In the order, stop, in the order dated 18/4/2023, the writ petition 237/2021 was also directed to be listed along with WPC 232/2022. Stop. WPC 232/2022. No, not WPC. The present writ petition is segregated from WPC 232/2022. Listed after?
2 weeks, my lord.
Listed after 2 weeks. Okay.
Much obliged.
Lordship, as per office noting dated 12/5/2023, Lordship, service report on respondents number 1 to 5 is still awaited, Lordship.
No.
It's the railway, Lordship.
Railways, they have a standing council.
Lordship, I was told that Miss Naksangtila, she used to appear in the earlier cases, Lordship. So I tried serving a copy to her, but she said notice has to go first and then she has to get instructions. After that, only she can appear, Lordship. I've been told that they don't
So
have a
what do we
standing
do?
policy right now.
Respondent 1 to 5.
Lordship. Since Lordship, the addresses are in New Delhi, so Dusty will also not be possible,
Ah.
Lordship.
You once again take steps by registered post,
Lordship, I can do that.
okay?
Lordship.
My lord, here I'm appearing for respondent number 6, state respondent.
Okay. 6, 7.
Yes.
6, 7.
6 and 7, Lordship.
Yes.
Any affidavit required?
No, I'm yet to receive instruction, my lord.
Okay. Miss Lucino, the learned counsel for the petitioner, shall take fresh steps for service of notice upon respondent 1 to 5 by registered post with AD within a period of
Lordship, 3 days.
3 days from today. Mr. E. Tibapom, the learned government advocate, appearing for the respondent numbers 6 and 7, submits that he is yet to receive instructions listed after 3 weeks
3 weeks, my lord.
on a date to be fixed by the registry.
Lordship, in the meantime, if the interim may be extended.
The interim order passed earlier shall continue till the next returnable date.
Much obliged, Lordship.
My pleasure, Lordship.
Yes.
I'm mentioning on behalf of additional AG, V. Sucre.
Okay.
The state is here to receive instruction, so I may grant 3 weeks time to obtain instruction.
Okay, okay.
Lordship.
MS Pichano submits that. Makes a mention, MS Pichano makes a mention on behalf of Mr. MSB Sokre, the learned additional advocate general Nagaland, and seeks adjournment of the case for 3 weeks to enable the state respondents to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
I pledge.
Excuse me for 2 minutes.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention on behalf of Sir Mo Ancient Lordship. Lordship, here I'm here to receive instructions, so kindly grant me 3 weeks' time, Lordship.
Lordship, as per the office noting dated 12/5/2023, service notice report for respondent 4 is still awaited, so kindly allow us to take dusty service.
What to do? For 4?
Dusty service, Your Lordship.
That's the service.
Yes, Lordship.
You have 4? 1, 2?
1 to 3.
No. You have 4?
1 to 3, Your Lordship.
You're mentioning,
On behalf of Mo Ancient
no,
Lordship,
4 respondent number?
1, 2, and 3.
MS so the learned counsel for the petitioner submits that she may be allowed to take steps for service of notice upon the respondent number 4 by dusty process. Prayer is allowed. The learned counsel for the petitioner shall take steps for service of notice upon respondent number 4 by dusty process within a period of
3 days.
within a period of 3 days from today.
Lordship, interim may be allowed to continue.
Pardon? The learned government advocate 6 for 3 weeks' time to file the affidavit in opposition. Yes,
Lordship, kindly grant 1 week,
within a period of
1 week.
dusty service within a period of 7 days from today. Listed after 3 weeks.
Obliged, Lordship.
What about this one? Even 45? Yes, I, just wait. Give I. Just wait. None appears for the parties. Listed after a week. Which one? Which, this one?
May I please, Your Lordship? Your Lordship, the State Council is not here, Mrs. Lucy, Your Lordship.
This is item 55. Yes,
Your Lordship, the matter may be heard, but the State Council is not here, the Mrs. Lucy, Your Lordship.
she was here.
Yeah, she was here, Your Lordship. And Ma'am Vehli as well.
Who is for the government? Mrs. Lucy or
Yes, Lucy for the red petition and for COP, Vehli, Your Lordship.
for the,
COP, for the contempt petition, Vehli is appearing, Your Lordship.
and who is for 167?
Lucy.
Which is the main case?
167K of 2020.
She was here.
Yeah, in morning she was here.
Okay, we'll list it next Monday.
Your Lordship, if Your Lordship kindly, we heard today, Your Lordship, it can be heard after break also, Your Lordship.
But where is Mrs. Lucy? Government advocate?
Lordship.
She was here in the morning.
Yes, Lordship.
Then why?
Lordship, we have seen one of our colleague to call her.
Okay, let us see. Let us see.
Your Lordship, ma'am.
Yes.
Yes, Lordship. I beg for indulgence in item 44. There's an interim.
Item 44.
For Your Lordship.
Item 44. Interim order passed earlier shall continue till the next returnable date. Okay. Yes.
Yes, my lord, the petitioner has page 10 of my petition.
All the parties present, no?
My lord,
Lordship.
Just wait, let me see.
Lordship, sorry for the indulgence, Lordship. This similar situated matter, this has already been settled in the apex court, Lordship. And here the facts and here in the instant
Almost.
case,
yes, almost similar.
almost similar, Lordship. So, Lordship, I've been told that review the petitioner, the respondent, they are likely to file a review before the apex court, Lordship, against this judgment and order, Lordship.
No, but the fact situation is quite different.
Lordship,
In the case decided by the Honorable Supreme Court on this case. The
Lordship,
fact situation is quite different.
facts is all.
So we should not blindly apply
Yes, copy paste.
the judgment of a Supreme Court or for that matter of a larger bench.
Lordship,
We
that
should not
is-
blindly apply.
Lordship, here in this case, Lordship.
Okay, let us see what was the ratio laid down in that case. What was the ratio laid down in that case by the Supreme Court? No ratio has been laid down. There was no ratio laid down.
Lordship. But however, the principle has already been laid down, Lordship.
What principle? Principle is the ratio itself. Principle of law laid down is the ratio itself. So what was the ratio laid down in that case by the Supreme Court?
Lordship.
The order was only passed on the basis of the facts. Placed before the court.
Lordship.
Yes, so
I mean, as your lordship has pointed out, my situation is in this particular Nishibi case, the wife approached the honorable court.
let us leave that
Yes,
aside. What is
yes.
your case?
So I may be allowed to first appointment, page 10. Page 10, annexure 1.
Just wait.
Sri Sholi is hereby appointed as work charge payender helper in place of Mr. Kutimu, who has been absorbed into regular care in the scale of pay of rupees 800 to 1475 per month, plus all other allowances. Under the rule, admissible from time to time with effect from the date of joining to the post. The appointment is purely temporary and may be terminated without further notice. In the interest of public service, Shuli is hereby posted under SDO Housing, bracketed H Housing, Oka. That is dated 27/3/2003, my lord. In service for name that
He was retired or he died?
he died.
He died. What is the date of his date?
09/04
Just wait, just wait.
09 0
09
04
04
2019,
2019.
my lord.
Okay.
Then
So how many years he had served? How many years of, how many months?
he have served exactly 16 years, 1 month, and 13 days.
16 years,
1 month, 13 days.
16 months, was 16 years, 1
1
month and 13 days.
My lord,
13 days.
my lord.
Okay.
So he was appointed under SDO Oka in by page 29, my lord. Or page 19, not 29. Page 19, annexure 3. In the interest of public service, such and such work charge vendor helper attached to the subdivisional officer PWD housing subdivision Oka. Under this establishment is hereby transferred and posted to the establishment of SDO PWD housing subdivision number 1. Kohima under this division with immediate effect, like any other regular employee. Page 11, my lord. His service was maintained. Service book was already finished. So the service book is maintained as per subsidiary rule. Is a one. So like As per SR 197, service book was maintained like all other regular employee, that is page 11. In his annual increment is given all along. Page 12, the appointment is clearly reflected. Appointed as work charge pay under helper in the scale of such and such. Joined with effect from 28/3/2003. Then annual increment was granted all along. Page 15, my lord. Service period from such and such 2006 to 2007. Verified with a voter in found correct. And released or from this subdivision by order number such and such dated 2008. That is from the SDO. Okay. Then Kohima also increment is effected all along. Then page 18 may be seen, my lord. Verified by the work charge and casual employees in pay was fixed. Then while working under STO1, Kohima division, page 20, he died.
Oh, come to page 18. Let's see this.
As recommended under the scheme of regularization in absorption of work charge in casual employees in revision of pay in wages by such and such 2015, 17/3/2015. In ANC letter number such and such, he has been fixed at rupees 4,540 as on 1/1/2015 with date of next increment 1/1/2006 in the scale of pay band 1 3,000 to 15,200 grade pay of rupees 1,300. Is by the SDO PWD housing subdivision number 1 Kohima. In he died on 09/04/2019, my lord. Page 20, death certificate. Then the petitioner applied for the succession certificate before the district initiation judge, principal district initiation judge. In succession certificate case number 180 of 2020 was issued to the petitioner. To prove, operate, transfer, close up late Suli service benefit, family pension, SBI account number such and such, Larry branch, Kohima, who expired on 9/4/2019.
Okay, next.
The petitioner, page 22, submitted, represented to the engineering chief for regularization of late solely work charge vendor helper for family pension in retirement benefits. My lord, I may be allowed to read it out for
Yes.
your lordship. Sir, on the subject cited above, I have the honor to state the following for your kind consideration in necessary action. That by office order dated 27/3/2003, inclusive one, my husband late Suli was appointed as work charge vendor helper under STOPWD housing subdivision OCA on temporary basis in the scale of the such and such, plus all other allowances under the rule admissible from time to time with effect from the date of tuning to the post by such and such, dated 26/8/2002. That by office order dated 3rd September 2008, he was transferred and posted to the establishment of subdivisional officer PWD housing, subdivision number 1, Kohima. That my husband died on 9/4/2019, leaving behind 2 school-going daughters, namely Nizuni, age 11, and Kreyeni, age 9. My late husband was the sole breadwinner of the family. In the family, entire family members are facing untold hardship to maintain our family livelihood. Therefore, I earnestly beseech your esteemed self to kindly regularize the service of my late husband for family pension and retirement benefits. And for the sake of your kindness, I shall remain ever grateful to you. Dated 4/9/2019. Yours faithfully, the petitioner, Mrs. Trilby. This was by the Chief Minister Office, Annexure 23. Page 23, Annexure 7. As desired by the Honorable CM, I am directed to forward here with an application received from such and such, requesting for regularization of her service of her husband, late Suli, work charge vendor helper under the establishment of SDU housing number 1, Kohima. I therefore request Engineer in Chief MPWD may kindly examine the matter on top priority for consideration. Then this DO letter was lost, so it was resubmitted by Annexure 21. The petition along with the recommendation was misplaced somewhere. That is why it was resubmitted on 4/9/2019. My lord, what I am trying to bring to your lordship notice is when pension was rolled to And you have to take your lordship to my affidavit in reply, where I includes the CC's pension rules. Page 15, madam. My learned government side also has referred to the same rule in their,
Affidavit in reply.
yes, up my affidavit in reply, filed on 22/8/2022, my lord. 22/8/2022. So what I'm trying to see is that my learned government respondent also have referred the pension rules. What they are trying to see is that I being a work judge, it is not applicable to me, to the present case. Particularly, in my affidavit, writ petition, para 7, I've specifically plated page 5 of my writ petition, para 7. In all this, the consolidated part of the CC's pension rules 1972, I have included in my affidavit in reply, page 15. If I may be allowed to refer to the rule 2 as a whole, my lord. May I start, my lord?
Yes, please.
CC's pension rules.
But you are putting the the cart before the bullock, because you first have to establish what is your right to regularization. It is only after regularization that you get your pension benefits,
My lord,
unless
that
and
is
until you are regularized.
that is why in my prayer I'm coming. I've stated that
Once you are regularized, you get the pension.
my lord,
But the question is whether you have a right to be regularized.
my lord, that is the whole issue is that. So we have to go to the pension rules. What does it say? So that this is
You first satisfy this code. You first satisfy this code as to your right for regularization. Then only then, when once this code is of the view that you have a right to be regularized, you get your pension.
my lord,
If you don't have a right to be regularized,
that is why what the pension rule says. When somebody has served a certain period of time. So when we go to 1972 rules, rule 2 is very clear that save as otherwise provided in this rule shall apply to government servant, including civilian government servant in the defense service appointed substantively to the civil service in post in connection with the affair of the union, which are born and pensionable establishment, but when it comes to but shall not apply to, I come under that.
which are you reading? Which para?
Page 15 of my affidavit in reply, CC Central Civil Services Pension Rules 1972.
Which?
My affidavit in reply filed on 22/8/2022. my lord.
So grant of
So application to whom this will be applied. Save as otherwise provided in this rule. This rule shall apply to government servant, including civilian government servants in the defense service, appointed substantively, number one, to civil service. I'm out in post. In connection with the affair of the union, which are owned unpensionable establishment in, but shall not apply to whom? Railway, casual, daily rated, paid from contingency, person entitled to CPF, member of All India Services, person locally recruited for service in diplomatic, consular, in other establishment in foreign countries, person employed on contract except when the contract otherwise provides otherwise. H, person whose term and condition of service are regulated by or under the provision of C contribution or constitution or any other law for the time being in force. So if we look in the first plus, it is out. I'm out. So what happened is that Government of India's order, number one, grant of pensionary benefits to temporary government servant retiring on superannuation, invalidation, and completion of 20 years. Now,
So there's two, it shall not be applied to this following categories of person.
yes,
Is it?
yes.
So what do you
Number
mean?
one is that it should be appointed substantively. That is the first condition. Appointed substantively. So my appointment is name, the name is work charge. So it cannot be taken as a substantive, number one. But the appointment was against a vacancy in the scale of pay on the whole time basis. So, my lord, what I'm trying to see is after the enactment, certain difficulty arises. That is why government takes a decision and give this order. Government of India's order, number one. What happened? Grant pensionary benefit to temporary government servant retiring on superannuation and invalidation on completion of 20 years. Earlier, now it is 10 years. A government, in terms of Rule 2 of the CC's Pension Rule 72, a government servant, including civilian government servant in defense, appointed substantively, my lord, to a civil service, a post in a pensionable establishment is eligible for grant of pension in DCRG. But a government servant who at the time of retirement from service does not hold a lien. I was not holding a lien on a permanent pensionable post is not eligible for pension in DCRG, but eligible for terminal gratuity under sub-rule such and such of the CC's temporary service rules 65. Now, the question is, the question of grant of pension to government servants who retire after long years of service without being confirmed in any post has been under the consideration of the government. It has been decided that the government servant who in his retirement from service and attaining the age of superannuation or and is being declared to be permanently incapacitated for further government service by the appropriate medical authority after he has rendered temporary service of not less than 20 years, which is now 10 years, shall be brought within the purview of CC's pension rules 72. So it is brought all those people who doesn't have any leave. in the condition holding a pensionable post in a substantive capacity shall be dispensed with in its case. Consequently, such a government servant will be eligible for grant of superannuation or invalid pension, DCRG, and in my case, it is family pension. In accordance with the provision of the 72 rules. Then,
Suppose this court holds that you are not eligible for regularization. What is the,
my lord, that is what I am saying. See, I'm not regularized. No, I'm not saying that I have been regularized. What I'm trying to say is that the government have given an order that because of such a situation, person who was not holding any pensionable post, who have completed 10 years, shall be eligible for pension as per 1972 rules.
completed 10 years of what service? Completed 10 years of what service?
There is any kind of service in the government service. It may be this or that, but painter, helper there is regular service of that. So there is no question of me equating with any other adjustment, painter, helper.
You are coming to this court because your service was on contract. And you are.
Work charge,
And you are coming to this court for regularization. So you cannot say that you are actually in some capacity which gives you permanency.
My lord, that is what I'm trying to see by the government of India's decision. The decision is that the question of grant of pension to government servant who retire after long years of service without being confirmed in any post, even me, in my case. Has been under the consideration of the government. It has been decided what? That the government servant who in his retirement from service and attaining the age of superannuation or on being declared to be permanently incapacitated for further government service by the appropriate medical authority after his rendered temporary service of not less than now 10 years shall be brought within the purview of CC's Pension Rule 72. And the condition of holding a pensionable post in the substantive capacity shall be dispensed with in this case. Consequently, what will happen? Such a government servant will be eligible for grant of superannuation, invalid pension, DCRG, and family pension in accordance with the 1972.
Yes, Mr. Ncham, you also give your views on this pension.
No.
What is your views?
Lordship, Lordship, I have also done some similar cases on this, but factually it was a bit different. In my cases, Lordship, is placed tomorrow. After rendering service, Lordship, Supreme Court has already held. You cannot deny a person of his pension benefit when he is unable to earn for himself. You have utilized the service of the person. You cannot just let the person go empty-handed. That is the ratio laid down by the.
But he has served for 16 years.
16 years, Lordship. Now, going by the CCS pension rules, Lordship. Now, there's a judgment of the Honorable Apex Court also. Now, if you have rendered more than 10 years of service, you are entitled for regularization. The rules is very clear, Lordship. And basing on this rule, Lordship, there have been a canton of decisions, Lordship, by the Apex Court as well as this Honorable Court also. So on the other way around, Lordship, I cannot give my view on that, Lordship, but counting the 10 years.
Do you have citation, Supreme Court? Do you have citation
My lord.
on entitlement of pension after serving for 10 years in a temporary capacity?
Prem Singh, my lord, 2019, then SCC.
Just give me your citations.
Itu sampai that time. My lord, I have a photocopy of the judgment also. It's a bit lengthy, but the operative portion is it. Para 35 and 36, my lord. 34 and 36. Page 541, my lord. 541.
With Prem Singh Para,
Para 34, page 541. Para 34, I may be allowed to read out. 34, as it would be unjust, illegal, and impermissible to make a forced classification to make Rule 3 clause valid in non-discriminatory, we have to read down the provision of Rule such and such involve that service rendered even prior to regularization in the capacity of work charge employees.
no, Mr. MT,
My lord,
what I understand is this is prior to regularization. In this case, maybe this person must have been regularized and then
my lord, I understand your lordship, but
yes.
what I'm trying to say.
I want a ruling in support of your case. You are not regularized.
My lord,
This speaks about regularization.
in my lead petition, I've included Annex 1 of this honorable court,
Give me Supreme Court.
page,
I may differ and refer it to a larger bench.
my lord. Page 25 of this honorable
I
court.
have seen.
Yes,
Give me a Supreme Court judgment which supports your case exactly. Because what you are actually preempting case is about regularization and the period rendered in before regularization should also be considered. That is the case.
my lord, in the Prem-Singh case also it is clearly given that
Yes, that's why in Prem Singh's case, somebody is regularized. And the period before regularization should be taken into consideration for pension. That is what I read.
I may be allowed to read out the whole, the two para only.
The para which you have read, I
Yes.
think that the facts are different. Para 34 minus para 34, which para do you want to read?
My lord, what it is that it should be counted toward qualifying service even if such service is not preceded by temporary or regular appointment in a pensionable establishment. In my case, it is a pensionable establishment.
Pardon?
Nomenclature may be whatever you call it.
Yes,
Together is a pensionable establishment.
I don't agree unless you're regularized.
So also is whatever be the nomenclature, unless it is outside that pensionable establishment.
Just because actually there are other posts as a painter or chowkidar and all this, that doesn't mean that if you are appointed in that post, you are regularized. There should be a formal order of regularization.
My lord, it is not there. I'm not done that. I'm not saying that I have been regularized. But what I'm trying to see is that work charge employee contingency paid fund employee or
Which para?
para 34 or non-pensionable establishment shall also be counted towards the qualifying service. Even if such service is not preceded by temporary or regular appointment in a pensionable establishment. The Supreme Court is very clear. Even if it is not preceded by temporary or regular appointment. That also not even in a pensionable establishment. Then para 36 is malo. Not necessarily that somebody have to be regularized. It needn't be preceded by temporary or regular appointment in a pensionable establishment. Then para 36, there are some of the employees who have not been regularized in spite of having rendered service of such and such or more years, whereas they have superannuated as they work in the work charge establishment, not against any particular project. Their service ought to have been regularized under the government instruction, even as per the Umadidi. This court in the decision has laid down that in case services have been rendered for more than 10 years, exactly 10 years, that is as per the rule, without the cover of the court's order, as a one-time measure, the service be regularized of such employees.
This is not applicable to your case.
My lord,
You were 2003 appointee.
my lord,
In order to let this apply, you have to be appointed prior to 1996.
this is a 2019 decision of the Supreme Court.
This is 2019 decision,
My
but
lord.
you see the citation which you are reading. If you go by this citation, then you have to be appointed before 1996
My lord, it's
to get the benefit of Uma Devi's case.
my lord, what it is interpreting Umativi case. Pension rule 10 years is the minimum.
That is why
why it is-
there I want to be satisfied. This this judgment has referred to Uma Devi's case. Don't refer to Uma Devi's case because Uma Devi's case does not support your case.
My lord. But what I'm trying to submit is that pension rules qualifying the length of service is 10 years. So the in Prem-Singh case also it is more than 10 years. Without the cover of the court's order. So as a one-time measure, the services be regularized of such employees. 10 years completed, it should be regularized. That is the Prem-Singh rule.
Mr. MT,
My lord.
come to page 541. If you are talking about Uma Devi's case, then see that this court in the said decision, you start from there. It talks about Uma Devi's case. What you are reading is relating to Uma Devi's case.
My lord.
So I'm saying that Uma Devi's case does not support you, so don't minus Uma Devi's case, you make your submission.
That is why-
Uma Devi's case does not support you because your date of appointment was 2003. It does not support.
My
you.
lord, but the issue in this Prem-Singh case is that those who have completed 10 years, they have a right to be regularized as a one-time measure. There is-
Regularize, see,
We have-
Mr. MT.
Yes,
Regularize as a one-time measure is to do with Uma Devi's case.
my lord,
You minus that. You minus that.
my lord.
And then you actually make your submission from your case point of view, that is 10 years, if you have served 10 years, then you are entitled to pension.
My lord, then I may be allowed to minus that Uma TV.
Huh?
Then let me come to same para, page 542. In the facts of the case, those employees who have worked for 10 years or more should have been regularized.
That is Uma Devi's case.
My lord, no, it is.
That is Uma Devi's case. That is actually having a reference to Uma Devi's case.
My lord, why?
Those who have completed 10 years and above should be regularized. That is in the context of the judgment laid down in Uma Devi's case. So I'm asking you to make submission minus the Uma Devi's case.
My lord, I'm under Prem Singh. It is just a reference to the Uma.
Prem Singh has made a reference to Uma Devi's case. That's why I'm saying.
Yes, I
am
understand.
saying,
what
I'm
your
saying,
lordship
make your
is.
submission minus Uma Devi's case.
My lord. So it is clear that it would not be proper to recollect them for consideration or of regularization as others have been regularized. We direct their services be treated as a regular one. However, it is made clear that they shall not be entitled to claiming any dues of difference, in which is had they been continued in service regularly before attaining the age of subordination.
Say, Mr. Inti, if we are to apply Uma Devi's case, you cannot be regularized.
My lord, that is why I am not passing my.
But you are reading Uma Devi's context.
No, my lord. Thing is, the difference is this. What it is.
You just, you just,
my lord, I may be allowed.
submission. Just make your submission on the ground that since you have been in service for the last 10 years, more than 10 years, you are entitled to pension benefits. And in that context, you support your submission by some very good citation. Let me see.
My lord, I may be given some time.
You may have a case.
My lord, I have understood your lordship.
That's why I'm making a, I am actually stating, I'm stating that minus Uma Devi's case, you are actually submitting, that
Yes.
those who have completed 10 years or more,
Yes,
okay,
yes,
irrespective of the nature of their service,
my lord,
is entitled to pensionary benefits. You are making that submission.
my lord.
That's why I am asking you to actually confine your submission on that point and to give a proper citation
My lord.
of the Supreme
My
Court.
lord, Prem Singh, my lord, I may be allowed to make the difference. Uma TV was a case of regularization.
Yes,
So it has specifically deal with regularization.
yes.
Whereas Prem Singh is a decision on service law, pension, the heading.
But if you're reading para 36,
My lord,
if you are reading para 36, then it speaks about regularization.
my lord, that is why,
So, and that regularization has a reference to Uma Devi's case.
my lord,
That's why I am saying, don't invoke Uma Devi's case. Uma Devi's case, if you invoke Uma Devi's case, then actually you may not have a good ground for regularization.
against me,
Yes,
yes.
that's why I'm saying minus the Uma Devi's case. If you can kindly make your, if you can kindly focus your submission on the
Pension.
10 years,
Yes.
on the 10 years you have rendered to the government of Nagaland,
My lord,
and that you are entitled to pensionary
my
benefits
lord,
in terms of CCS pension rules 1972.
my lord.
And if you can give me some good citations, of course, I think we will be able to.
So I may be given it at least one or two things.
Because I don't know, but I find for myself, I find pension a little complex.
My lord, your lordship query is, Uma TV clearly talks, deal with regularization. Prem Singh is a question of pension.
Pension.
So Uma TV, there was no question of pension. Pension was not the issue there.
No.
So Prem Singh is,
But what you are referring to 36, you are actually making an emphasis on para 36. But para 36 refers to regularization.
my lord, para 36 is referred, it is not only one judgment referred in this decision. It is referred to many decisions. But the ratio has come down to one principle, that is, ratio is 10 years, yes, qualify for pension. Whatever be the nomenclature of the appointment. However, apart from that, I may be allowed to place search some more citation.
This is not a academic discussion, Lordship. This is a 2022 judgment also. I'll be placing tomorrow, Lordship,
Yes.
where the ratio has been explained a little bit. This is judgment of 2022. I don't have it today.
On the pension?
Yes, on the pension, yes.
Okay,
Because
so
the ratio laid down is like, you have utilized the service.
no, that of course, so far as regularization, that's why in the morning also I was saying.
Yes, Lordship.
That ratio has been laid down by the Supreme Court. You have utilized the service. You have taken the service for more than 30, 40 years.
Yes.
And you cannot one fine day throw him out.
Yes.
So,
So basically, my learned friend is trying to come to that line, Lordship.
but that is to do with regularization.
Yes. Yes.
Ah,
So that distinction has to be made. Lordship.
yes, exactly. That's why I am again and again asking our friend,
Yes.
give me that distinction.
Yes.
So you please come and satisfy this court.
My lord,
But on your specific point, pension,
my lord,
10 years you have rendered, so you're entitled to pension,
my lord,
not about regularization. Okay, if regularization, then maybe you have a weak case
my lord.
when you have rendered only 15, 16 years. Because we have the differentiate facts. Those who rendered 30, 35 years and those who rendered 10, 15 years.
Yes.
I think that facts has to be differentiated. So,
But at the same time, my lord,
Earlier it was 20 years. But the CCA
earlier.
control, they have cut it down to 10.
10 years.
So once you have completed 10 years,
But see, I see, that's why I actually face some complication on that.
yes, Lord.
What is the nature of service for that 10 years?
10 years, yes. Whether it was
See,
on the
yes.
basis or yes.
So to assess the court,
yes, Lord.
if you can kindly come properly prepared on that, what should be the nature of work for 10 years to enable one to get pension?
Yes.
in Prem Singh also, it is clearly dealt. It may not be preceded by any regular appointment or confirmation, whatever you call it. It is not necessary.
But what is that nature of appointment?
Yes, Lord.
Kindly, I think, let us help one another in this.
My lord,
Lordship, basically what Lordship is asking is whether it will cover even casual or work charge.
Whether it'll cover even casual work charge or any type of appointment.
The nature of
my lord,
the nature of appointment.
Prem Singh is very clear on that.
Is the distribution.
Casual,
Yes.
whatever be the nature of appointment is very clear about that.
Okay.
Yes.
Of course, I'll come out with all that relevant bara. It doesn't say that casual work charge contingency, whatever be the name, that is what it is clearly given here.
That means all fortuitous appointments.
Any kind of appointment. Because somebody was serving under the government, whatever be the nature of appointment, that is what brings.
So yes, I think you come like more prepared on that issue.
Yes.
My lord,
More particularly on that.
I think
nature.
we need some very good academic
Yes.
discussion on this.
my lord,
Okay. So we'll listen on next Monday.
my lord. Part hurt, my lord.
Not part hurt, this is always a very difficult situation for us. We are like a shuttlecock anytime
Within this week, my lord,
Listed on,
Thursday,
no, not Thursday, Friday, listed on 29/5/2023. So please come properly prepared to assist this court on that issue.
my lord.
Ncham also, please come prepared. You are in this case, no?
Lordship, I'm for AG.
80,
I have nothing to
80.
say.
You have nothing to say, but academically you have many things to say.
Lordship.
Yes,
Because,
80 will have a big C.
because I think you should be the one to properly assess this court also.
Lordship,
From the
I'll
outside.
definitely, Lordship, yes.
So, but also you come.
In fact, Lordship has pointed out the main issue involved,
Correct.
the nature of pointing, yes.
So that if we can know that what are the crux of the case, then we may be able to write good judgments. If not, writing.
Lordship, even going by the Nagaland Government Service Conduct Rules, the definition of Government 7 is there. So if my learned friend can
Conduct
assess on that
rules.
one also, yes.
Nagaland Government Service Conduct
Yes,
1968.
68, yes.
68.
Yes. So there, the
So-
definition of Government 7 is.
So
there.
yes.
So who are the Government 7?
Ah.
So his main issue is that Government 7 may be a regular, maybe a contingency paid, but since he's in the service of the government,
So kindly,
yes, Lordship.
Come with
try to
all
assist.
this.
Yes, I'll assist support. Also.
okay, Monday, let us keep time for that case, for this case.
Yes.
Okay.
Much obliged.
Obliged.
Yes. Yes, ma'am, no government advocates. I saw them peeping, but they are not interested, maybe.
Your lordship, this is been happening, your lordship, time and again, your lordship. The matter is being fixed, but has been fixing your lordship since 22nd of June 2022. So it's much as 6 times.
Mr. Veto, kindly inform Miss Lucy,
Lordship.
listed again
Your
on
lordship, from
29.
Thursday, your
No,
lordship.
not Thursday, Friday, on 29.
Lordship.
Your lordship, they have already admitted that my service is, I'm eligible, your lordship, for regularizing of my service. They have already admitted. Your
Let
lordship.
us get
So-
let us get their answer on that day, okay? Listed again on 29/5/2023. Okay,
Lordship.
please inform Miss Lucy, it is
Lordship.
it is made clear that if the councils are not, if the council for the parties are not represented, the matter shall be, the matter shall proceed ex parte.
Obliged.
I oblige.
Okay.